petition. It starts
Huh?
at serial number, it's part 2.
Well, it's the bookmark 52.
Bookmark 52.
Judgments
Very
compilation
got
too,
it.
na?
Thank you.
390.
Nah,
Yes.
got it.
अच्छा 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 sorry no sorry I मेरी गलती हो गई
Kuldeep.
actually.
It's 52 in the bookmarking, isn't it? Is
Thank
it
you very
Deep
much.
Singh Bishnoi? Right. 2015-12 SEC 381. Mr.
Yes.
Well, even if I'm not legally sound, I'm trying to sound technically correct by pointing out all the bookmarks.
No, that's good.
Your Lordship.
You're making progress.
I'm inviting upon myself, Your Lordship. Would Your Lordship be kind enough to have para 14? Yes. In the meantime, proceedings before the Speaker continued, and since the same were not being concluded in terms of the assurances given, the Division Bench of the High Court directed the Speaker to file an affidavit on or before 11/11/2011. Finally, being dissatisfied with the progress, the pending disqualification petitions before the Speaker, the Division Bench took upon the letters patent appeals on 2/12/2011 when the directions are given to the production of the entire records of the matters pending before the Speaker. On 7/12/2011, the relevant records of the proceedings before the Speaker were submitted to the High Court, which adjourned the matter till 19/12/2011 for further consideration. However, as alleged on behalf of the appellants, the bench was not constituted on 19/12/2011, and without any further hearing or giving an opportunity to the Speaker's counsel to make submissions on the status report, the High Court proceeded to pronounce its judgment on the letters patents appeals. By its judgment, which has been impugned in these proceedings, the division bench held the direction of the learned single judge directing the Speaker to decide the disqualification petitions within a period of 4 months. However, while disposing of the matter, the division bench stayed the operation of the order passed by the Speaker on the merger of the So it also declared 5 MLAs who have filed separate appeals before this court as being unattached members of the assembly with the right to attend the session only. It was directed that they would not be treated either as part of INC or HJC party, with a further direction that they would not hold any office either. It is aforesaid directions and orders which have resulted in the filing of several special leave petitions before this court by the Speaker and 5 MLAs. As a consequence of the order of the Speaker, passed by the division bench of the High Court, the 5 independent appellants before us have been prevented from discharging their functions as members of the Haryana Vidhan Sabha even before the disqualification petition filed against them by Shri Kuldeep Bishnoi could be heard and decided. Then para 46, my lords, on page 965. Last para on that page, para 46. My lords have that? The appeal filed by the Speaker of the Haryana Vidhan Sabha against the judgment of the division bench of the High Court is not therefore capable of being sustained, and the appeals filed by the Speaker is accordingly dismissed. The other appeals preferred by the 5 disqualified MLAs have therefore to be allowed to the extent of the directions given by the learned single judge and endorsed by the division bench that 5 MLAs would stand disqualified from effectively functioning as members of the Haryana Vidhan Sabha till the Speaker decided the petitions regarding their disqualification within a period of 4 months. In our view, the High Court has no jurisdiction to pass such an order, which was in the domain of the Speaker. The High Court assumed the jurisdiction which it never had in making the interim order, which had the effect of preventing 5 MLAs in question from effectively functioning as members of the Haryana Vidhan Sabha. The direction given by the learned single judge to the Speaker as endorsed by the division bench is therefore upheld to the extent that it directs the Speaker to decide the petitions or disqualification of the 5 MLAs within a period of 4 months. The said direction shall therefore be given effect to by the Speaker. The remaining portion of the order disqualifying the 5 MLAs from effectively functioning as members of the Haryana Vidhan Sabha is set aside. The said 5 MLAs would therefore be entitled to fully function as members of the Haryana Vidhan Sabha without any restrictions, subject to the final decision that may be rendered by the Speaker in the disqualification petitions filed under para 6 of schedule 10 of the Constitution. Now, my lords, this is of course the same principle as in continuation with Shivraj Singh Chauhan, which I had read out to your lordships.
Yes.
And there was a question that your lordships had put to me on the day before yesterday, that could someone say that Shivraj Chauhan was only on resignation. That's why I read out those paragraphs that Shivraj Singh Chauhan, your lordships don't just deal with resignation of MLAs. Your lordships categorically in paragraphs 78 to 81 talk about disqualification petition under the 10th schedule. And say if disqualification petitions under the 10th schedule are pending, doesn't mean in the meantime they will stop discharging their functions as a member of the House. My next judgment for your lordships' kind consideration, my lords, is Rajendra Rana.
That would be
Ju-
judgment's compilation.
Judgment, no, my lords, now on a point that I'm relying on. Till now, I distinguished on what they were relying on. They were relying on it for two purposes, ex post facto, and that your lordships as a court of first instance can decide. Ex post facto, I explained to your lordships saying that it was qua the speaker, that the events to be seen by him were on the day when they incurred disqualification, not subsequent events or split. And as far as your lordships deciding as a court of first instance was on an issue where it had been there in the High Court for 3 years, then the High Court remanded it back. When it came to the Supreme Court said the assembly election, the term is to expire by the end of the year. So let's decide the matter. That is quite different from this matter in every which way. Now, my lords, kindly have Judgment Compilation Volume 1, bookmark 19, page 834. Context of that exposed for these two. Para 25 on page 855. My lords, before I start, let me tell you, lordships, the context why I am citing this judgment.
Para 25. PDF 855.
My lord, the Chief Justice.
855.
Yes.
My lords, the reason I'm citing this judgment is that in this, at that time, para 3 as a defense was available. At that time. Even when para 3 as a defense was available, the Supreme Court said that the speaker deholds disqualification, does not embark on an independent inquiry to find out about splits in the political party. He only takes a limited prima facie view of the split within the political party. The reason I'm citing is even when, this is not a question of split, this is not a question of merger, but even where it was a question of split and para 3 was still on the statute book, the court said the speaker will not embark on an independent inquiry into splits in the political party. Please have para 25 for a minute, my lords, on page 855.
It is only a jurisdictional fact for him to enter to give a finding with respect to disqualification.
Grateful. Grateful. That's all. I couldn't have put it better. That's all. My lords, may I?
Yes.
Yes.
25. In the context of the introduction of sub-article 2 of Article 102 and Article 191 of the Constitution, a proceeding under the 10th schedule of the Constitution is one to decide whether a member has become disqualified to hold his position as a member of the Parliament or of the Assembly on the ground of defection. The 10th schedule cannot be read or construed independent of Article 102 and 191 of the Constitution and the object of those articles. A defection is added as a disqualification, and the 10th schedule contains the provisions as to disqualification on the ground of defection. A proceeding under the 10th schedule gets started before the Speaker only on a complaint being made that certain persons belonging to a political party had incurred disqualification on the ground of defection. To meet the claim so raised, the members of Parliament or Assembly against whom the proceedings are initiated have the right to show that there has been a split in the original political party and then they form 1/3 of the members of the legislature party, or that the party is merged with another political party and hence para 2 is not attracted. On the scheme of Article 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the Speaker seeking a disqualification of a member or members concerned. It is therefore not possible to accede to the argument that under the 10th schedule to the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule to the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But this is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question. He was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of para 6 subclause 1 of the 10th schedule to the Constitution, and that even if it did, the power of judicial review recognized by the court in Quixote Holohorn is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as a part of disqualification of a member of the House. That disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10th schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10th schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10th schedule or the rules made thereunder do not contemplate the Speaker embarking upon an independent inquiry as to whether there has been a split in the political party or there has been a merger. Therefore, in the context of 102 and 191, the scheme of the 10th schedule to the Constitution, we have no hesitation in holding that the Speaker acts under the 10th schedule only on a claim of disqualification being made before him in terms of para 2 of the 10th schedule. And now, my lords, kindly read this with para 37, and then I'll come back to one more para I need to show. Please first have para 37. PDF page 862, my lords. That's the last of it. My lords have para 37.
Yes.
Thus, in the above decision, it has been clarified that it is not enough that a claim is made on a split in the original party, in addition to showing that 1/3 of the members of the legislature party have become out of the party, but it is necessary to prove it at least prima facie. They say prima facie, yes, but all the time emphasizing on this whole thing that the Speaker will embark upon a full-fledged inquiry into the political party, the talukas, the districts, and decide on a split in a political party is without jurisdiction. Quite apart from the fact that you're seeking to draw an artificial distinction which does not exist. And I'll come to that judgment. That para of Sadiq Ali, I'll show to your lordships, which is important for this. Now, my lords, kindly have, only for that other issue of ex post facto, I'll just sum it up on para 34 of the same judgment. I just need to show that.
Here comes the test. The test is here.
Yes, yes. 860. 860. Para 34. My lords have that?
Yes.
As we see it, the act of disqualification occurs on a member voluntarily giving up his membership of a political party or at the point of defiance of the whip issued to him. Therefore, the act that constitutes disqualification in terms of para 2 of the 10th schedule is the act of giving up or defiance of the whip. The fact that a decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislature. Similarly, the fact that the party could condone the defiance of a whip within 15 days or that the Speaker takes decision only thereafter in those cases cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. Therefore, in the background of the object sought to be achieved by the 52nd Amendment of the Constitution and on a true understanding of para 2 of the 10th schedule with reference to other paragraphs of the 10th schedule, the position that emerges is that Speaker has to decide the question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies the whip. It is really a decision ex post facto. It is in this connection that the observation is made that subsequent facts of split, seeking a defense of split under the 10th schedule will not be looked at. You will see on the day you went to meet the governor in the facts of this case, some of the MLAs with the opposition party and asked the Samajwadi Party to form the government was an act which was squarely hit by 21A. And that is why, my lords, I had respectfully submitted and read out instances of Ravi Nayak of this judgment. They were overt acts under 21A. Yadurappa's judgment clearly says merely because within the party I say I do not support a particular coalition of a government is not a 21A case at all in the matter. In any case, my lords, who will decide it? Whether it's a 21A case or a 21P case, it still has to be the speaker under para 6 who's the sole and exclusive constitutional authority to decide it. So A, I'm not a 21A case. B, Yadurappa is held merely because you show support to a government is not a 21A case. And thirdly, my lords, in facts of these cases, the facts which have to be seen are the facts on that date. The ex post facto is in that context. Ex post facto doesn't mean that since your disqualification will be decided on the date you incurred it, all your acts as members of parliament or members of the legislative assembly get annulled in the process. And that is the deduction sought to be drawn now from the words ex post facto in Rana's judgment. Now, my lords, kindly have just last two judgments and I'm done. Kindly have Rameshwar Prasad versus Union of India. Same volume, bookmark 16, para 165. Relevant para 165 is at page 521.
What's the, sorry, page?
PDF page.
Page 521.
PDF page 521.
Same compilation.
Same volume,
PDF is 390.
521. My lords have para 165. May I, my lords?
Yes.
If a political party with the support of other political party or other MLAs takes a claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. Governor is not an autocratic political ombudsman. If such power is vested in the governor or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power of 356. Remedy for corruption or similar ills or evil lies elsewhere and not in Article 356. In the same vein, it has ought to be held that power under 10 schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature. Dealing with question whether power of disqualification of members of the House vests exclusively with the House to the exclusion of the judiciary, which in Britain was based on certain practices of the legislature, as far as concerned, it was said in Quixote. It is therefore inappropriate to claim that determinative jurisdiction of the Speaker or the chairman of the 10th schedule is not a judicial power, is within the non-justiciable legislative area. So the reason I'm citing this judgment, my lords, is for the fact that for A, of course, we say that the chief minister lost his majority, the coalition government could not survive. We within the party were the overwhelming majority. And even if their argument was to be accepted, which I'm not conceding, that, oh, you cobbled it up together in an illegal mean, etc., which it is not. It was a perfectly legitimate government which was sworn in. The governor is not to sit on these matters and make his assessments if a probable, plausible coalition or partnership comes before it and says, because ultimately at the end of the day, someone has to head a government, my lords. My lord, the Chief Justice posed a question to me yesterday. After the sitting Chief Minister resigns, someone has to be sworn in. Now, if a set of people come and show that they have a sizable or an overwhelming majority, he says, go and test it on the floor of the House. And what time does he give? 2 days to do it. And your lordships have normally said those cases where you're given a month, 2 months, and that is scope for horse trading, etc. He immediately calls for a floor test in exercise of his constitutional duties and obligations. and say, prove your majority. If you are the new government which is taking its claim within the same political party, now in coalition with another political party who is a pre-poll ally, what is wrong with that decision of the governor within 2 days? Now, my lords, kindly have lastly, Sadiq Ali for a completely different proposition. Volume 2, bookmark 39,
Same volume.
PDF 85 at 98. Can we repeat that? Volume 2,
Bookmark 39
bookmark 39.
starts at PDF page 85.
The judgment starts at page PDF 85,
Relevant para at PDF 98.
relevant para at PDF 98.
Para?
98, para 27, page 98. Well, before I proceed to read, my lord, the Chief Justice, can I? Before I proceed to read the judgment, my lord, the reason I'm citing it is I right through said, apart from all other arguments, that you cannot segregate the two. One of the principal arguments for recognition of a political party under 6A and 6B of the symbols order, those provisions I have not read, of 6A and 6B for a continued recognition. And recognition of a political party is the number of percentage of votes polled by MLAs, MPs, its strength in the House. These are all relevant factors. So what happens in the legislature can't be just kept aside. That's a relevant consideration within it. So to say that they're two completely distinct things and political party is distinct and legislature party is distinct is not correct. And that is what Sadiq Ali also notices in this paragraph, is what I wanted to show it for. The other paras, my lords, I'm not bothering your lordships on all those powers of the EC because we are not getting into that. It may be mentioned that according to para 6 of the symbols order, one of the factors which may be taken into account in treating a political party as a recognized political party is the number of seats secured by that party in the House of People or the state legislature, assembly, or the number of votes polled by the contesting candidate set up by the such party. The number of seats secured by a political party or the number of votes cast in favor of candidate of a political party can be a relevant consideration for recognition of a political party. One is at a loss to understand as to how number of seats in parliament and state legislatures held by supporters of a group of political party can be considered to be irrelevant. We can consequently discover no error in approach of the commission in applying the rule of majority and numerical strength for determining as to which of the two groups of Congress J and Congress O was the Congress party for the purpose of para 15 of the symbols order. Now, that is a separate matter which your lordships are dealing with, where this has also become one of the considerations. And this para of Sadiq Ali in that other matter that your lordships are dealing with. That this is one of the indicators, valid indicators available. So to come and say that you've only done it in the legislature party, there's nothing in the political party. And their entire argument, my lords, was, with great respect, that on 18th you had a meeting and you showed the minutes of 27th. It's factually wrong. I'll argue it there in that matter. They're two separate meetings. They're factually incorrect statements made that you had a meeting on the 18th, but there are no minutes, there are no signatures. That's not the subject matter of the reference before your lordships at all. And I'll argue it there. There are two separate meetings. Requisite members attended it. And please do not confuse the minutes of one meeting with the holding of another meeting. My lords, I'm very, very grateful. Your lordships have been extremely kind and patient. I'm extremely grateful, my lords, and the 3 notes I've given. I'm extremely grateful.
Thank you, Mr. Kaul. Who will now argue? Mr. Jitnani will argue.
I'm told Mr. Salve is logged in, so he'll just make a brief submission first.
Who's your parent?
Sir, you are not audible, sir.
Hear me now?
Yes, Mr. Sarve.
Yes. My lord, a short submission. I mean, Mr. Kaul has addressed your lordship on issues which perhaps don't arise really, if your lordship sit back and consider. What is it that your court is called to decide today? I mean, we have answered everything on merits, but my lord, if your lordship take a step back and see what is it that your lordships need to decide. The first step in this entire saga
Mr.
was,
Salvi, appearing for whom?
Mr. Salve, who do you appear for?
yes, I'll just give your lordship the numbers.
Sorry, who are you appearing for?
Yes,
So the same set of parties.
There are many respondents. Yes.
So different respondents.
Yes,
multiple
all
Same,
respondents. Yes.
another set of petitions.
Really, we have to only distinguish the case of the governor because the governor will be represented by
The solicitor, yes.
Whose client is not allowed in any case. There is no confusion about whom I appear.
And the rest of Mr. Kaul, Mr. Salve, Mr. Jetmani, Mr.
We'll give appearances.
Appearing for the individual
Yeah,
party.
that's right.
Fair enough, no problem.
Respondents. Okay.
And my lord, the only thing I wanted to broadly respond to is Mr. Sibal's broad submissions about what role the court should take onto itself to prevent political immorality. But this is a very slippery slope. And your lordships have always resisted the temptation in certain areas to go beyond a particular point. Interpreting the 10th schedule undoubtedly will be inspired by the objects of the 10th schedule, namely to bring in a degree of political morality in public life. But beyond that, my lord, I would submit for the court to embark on this journey would be extremely perilous because there are very delicate balances between institutions involved here. Mr. Uddhav Thackeray resigned. The governor called for a floor test of a sitting chief minister. There was no floor test held. The submission is if he had not called for the floor test and if this had happened and if that had happened, he would have won the floor test. A submission which your lordships should not even countenance for the reason we do not know what happens in that part of the world when it comes to defending the majority of a chief minister. And my lord, it becomes even more perilous in today's day and today's world of coalition politics. How do you know who would have supported whom on that momentous day? What if one of his coalition partners had said, sorry, I can see that you've really lost support of your party. We don't want to support you anymore. We don't know. And it is not for us to understand because these are matters beyond our understanding as lawyers. So, my lord, this entire submission that your lordship must assume a state of facts would have prevailed is extremely hazardous because this is in the realm, my lord, not of legal fiction. This is in the realm of the rough and tumble of politics. And I'm not suggesting any political immorality. My lord, why can it not be that two coalition partners say, we will not support you anymore. We've lost faith in your ability to steer the ship. We don't know whether that would have happened. Would it have happened? Would it not have happened? How can your lordships be invited to hazard that guess that if this had not happened, the but-for test, my lord, which we call in our in commercial law for breach, the but-for test cannot apply here. Yes, if Mr. Thackeray had contested the floor test, if he had lost by 10, and your lordships felt 16 disqualifications were affected, the court could have said, we need to fix this problem because of our refusal to grant the test, because your lordship said we will not stay the floor test. We will make it subject to our judgment. And your lordships would have been in a position to correct what went wrong. My lord, I know it's a much more mundane world in boardrooms and in company general meetings, but the principle is the same. Somebody says so-and-so should not be allowed to vote. Your lordship said count his vote separately and we'll see what happens to the resolution. And the reason is, my lord, suppose he had contested the floor test and lost by 70 votes. All this becomes academic. Yes, if they have defected, is the sin of defection purged? Maybe not. So, Maharaj, that's the first point which I wanted to make. If that has happened, then if I'm right there, that your lordship cannot and should not embark on any but for assumptions here. Because we do not know what would have happened on that fateful afternoon. Please, Malad, consider another scenario. I'm only giving these not because I'm saying this would have happened. I'm saying this could have happened, only to persuade your lordship not to go down this road. Let's take another scenario. These 16 were guilty of overt act. They did not show up for a meeting. Somebody says that constitutes abandoning your party. Another 20 people may have done something by which you say they have done an overt act. What do you know is lurking in the minds of others? Look at what happened, and I'm just to buttress this point, Manoj, look at what happened when Shinde came for his floor test. 13 of hardcore so-called supporters of Mr. Thackeray abstained from voting, which basically meant it strengthened his hands. Now, these things happen in public life. How do you know how many more were not harboring the intention of walking away that day? So, Malad, these are all I'm saying is this is rank speculation as far as we are concerned. The politicians may feel that they knew what was going on. And we've had, and I'm just bringing it to your lordship's notice, your lordship know this. We've had a very strange situation in this very state, in this very formation, where one government was sworn in, and within 3 days that government fell and another government had to be sworn in. So, but these things happen. And the person who got sworn in as the deputy chief minister with another formation became deputy chief minister. These fast-moving political waters take different turns at different points. We are not to speculate about them. Now, if I am right there, then Malad, that should be the end of the matter. What is the speaker's constitutional obligation? The general Bommai principle, which your lordship has been shown in para 395 of Bommai, is that please, Mr. Speaker, do not do a mathematics. And Mr. Governor, please do not do this mathematics of but for. Call for the floor test. Let this be decided on the floor. Malad, when governors have sacked governments doing head counts, your lordships have taken him to task saying you're failing in your job. Why? Because it is not for the governor to count heads. What Mr. Sibal and Dr. Singhvi are trying to do is persuading your lordships to count heads. Because unless you do a head count, your lordship must then come to the firm conclusion that the but for these, Uddhav Thackeray would 100% have won. That's head counting. So, my lord, what your lordship said, the governor shouldn't embark upon. Now the judiciary is being asked to embark down that road. Nothing can be more perilous than that, is my submission. Yes, we have a problem. We have a problem. We have the 10th schedule. Is the 10th schedule a perfect solution? No, it's not. It has its leaks. Parliament is, when the legislature sometimes tries to fix it. Sometimes there are conflicting interests. It is not fixed. Malad, the biggest example we have of criminalization in politics. We've had this problem all the while. We have problems about election donations. We have problem about election funding. We have problem about election spending.
Stature versus stature.
These are all problems, Malad, we can't cross beyond a point. So, Malad, first of all, I submit the first set of cases don't arise. Then comes the second situation. What did the governor do? He is left in Maharashtra without a chief minister. If he is left in Maharashtra without chief minister, he has to invite somebody to form the government. Now he had then two options. He has invited Mr. Shinde to form the government. Should he have allowed Shinde to continue without a floor test? That would have been worse than conducting a floor test. Where are we in this case? Everything is academic. Yes, the only thing which remains is the 36 pending disqualification petitions, which the speaker will decide. And if he gets them wrong, there is the High Court which will correct them. Your lordships are here which will correct them. We have, within the parameters of judicial review, your lordships have tested and corrected these orders time and again. That is, my lord, my first submission. My second submission is what happens pending the disqualification petitions. Your lordship has been shown the judgments, but let's, my lord, sometimes it helps. Let's go back on first principles. Please see two provisions of the Constitution, my lord, and whether your lordships find the answer there. 190.
Yeah, we've seen that actually.
Only point.
Your lordship has seen it.
We've seen it.
Correct, my lord? The point which I wanted to make is just show your lordship something in the language of 190, just for 2 minutes.
190 is parliament. We are more concerned about 180. Is that
69, no?
160?
The language is identical. I mean,
Identical. Correct.
yes, there's no. The principle of the two is very important. Let's see the compare the equivalent provisions. First see 173. These are qualifications. Person not qualified to fill a seat. I don't need to trouble your lordship with the details. And then we come to 190, which is houses of the state of legislature. So we are really concerned with 190 because we are talking about state. And 190 sub-article 2 tells your lordships, no person shall be a member of two or more specified, then after the expiration of the period, etc. We are not concerned because we are really concerned with sub-article 3A, becomes subject to any of the disqualifications in 1 or 2 of 19 of 191. So we may not go to 191. 191 applies to at both stages for being chosen and for being a member. We see our post occurrence of events. Unsound mind and stand so declared by competent court. A pendency of a petition in a court to declare somebody incompetent is not good enough. In pending insolvency is not good enough. Look at E now, my lord. If he is not so disqualified by or under any law made by Parliament. Now, my lord, today your lordship was told eloquently of how terrible it is to allow those hit by 10 schedule to continue. My lord, it is not every time that there is corruption because of which there is defection. There may be times where people may defy a whip. There may be time when there may be a split in a political party. Now that sub-article 3 has gone, you have a problem. And people may say, we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected on which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail and saying he should be allowed to come. Mr. Tulsi was arguing, and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, my lord, those kind of cases are pending. A person, my lord, a known mafia king, against whom there was a murder trial pending for publicly gunning down people, continued in office.
Where does it?
My lord, we have cases, and your lordships have dealt with these cases in the High Court and sometimes in appeal in this court. You have cases of the worst kind of electoral offenses pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you very much.
Now, with that, my lord, see the language of 191(2). A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then to paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes,
till here there is no problem.
yes,
The position under the Constitution is very clear,
yes,
and also the judgments of this court.
correct.
Concluded with this expression, the decision,
Yes,
the problem arises the time, context, and the stage at which speakers choose to take a decision.
yep. I was going to straight away address, but
There are
yeah,
the-
so
I mean, in
yes,
that,
yes,
it is in that context that
yes. Now, my
either
lord,
that either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come.
my lord,
So,
the
in
short
case
answer,
of pending 10th
Yes.
schedule proceedings,
yes,
the powers to be exercised either by the governor or the political process, as it were, goes on.
yes.
So makes the application